welcome to this explainer. Today, we are diving into an absolutely fascinating 2015 legal battle that pitted secular constitutional rights directly against mandatory religious personal law. Khuran Sannath Society versus the Union of India is a must-know case for anyone studying gender justice, state authority, and constitutional law. It asks a massive real-world question. Does the state have the power or the obligation to let you choose a secular law over your mandated religious code?
To make this crystal clear for your notes, we're going to follow a classic case brief structure today. We'll hit the facts of the case, the core legal issue, key rules and statutes, the arguments from both parties, the court's reasoning, and, of course, the final judgment.
Let's kick things off with Part 1. The facts of the case, and the very real human stakes involved. The petitioners here, which included the Khuran Sannath Society, an organization advocating for Quran-centric interpretations, came to the court with a heartbreaking, tangible problem. Picture this. A grandfather has two sons. If one of those sons tragically passes away, leaving behind kids of his own, well, under the rule of exclusion, those orphan grandchildren get absolutely nothing from their grandfather's estate. Nothing. As long as their uncle, the surviving son, is still alive, they are completely cut out. The petitioners argued that this specific legal mechanism was literally leaving vulnerable kids completely destitute. And it wasn't just about the grandchildren. The petitioners were also calling out a huge gender disparity. Under these mandated rules, daughters receive only half the property share of sons. Now here's the kicker. Many Muslims actually want to distribute their property equally, and they want to use the secular, egalitarian Indian Succession Act of 1925 to do it. But they can't. They're legally boxed in by the 1937 Sharia Act. So they were essentially asking the court for a simple choice: the right to opt out of the religious mandate and opt in to the secular one.
Which brings us directly to Part 2, the core legal issue. What was the massive constitutional question here?
The court really had to grapple with this. Does forcing a religious law on a citizen who actively prefers a secular one violate our most foundational rights? Specifically, does the 1937 Act's total lack of an opt-out for intestate succession, meaning when someone dies without a will, make it unconstitutional? Think about it. If the law mandates unequal treatment, doesn't that inherently violate Article 14's guarantee of equality before the law? What about Article 15, which strictly protects against discrimination based on religion or sex? And zooming out, does it violate Article 21's fundamental right to live with dignity? It's a giant legal puzzle.
Okay, moving on to Part 3. To really grasp the court's dilemma, we need to map out the key rules and statutes.
Because remember, judges don't just rule based on feelings, they are strictly bound by statutory text. If you look at the breakdown here, Section 2 of the 1937 Act explicitly uses the word shall. It's a mandate. Sharia law shall be the rule of decision. Now, interestingly enough, Section 3 does allow you to opt out for things like wills or adoptions, but it deliberately excludes intestate succession. So while the Indian Succession Act of 1925 is sitting right there as a perfectly secular, equal alternative, it's totally out of reach for these petitioners because of that rigid wording in the 1937 Act.
All right, Part 4, the arguments of the parties. How exactly did this legal clash play out in the courtroom?
The petitioners had a really compelling theory. They argued that the 1937 Act acts as an effective barrier to their constitutional rights. Sure, Article 25 protects the freedom to practice religion, but they argued, hey, it definitely doesn't authorize the state to force a religious law down the throat of a citizen who is actively begging for a secular one. Makes sense, right? But on the flip side, the Union of India and religious respondents heavily invoked religious freedom and legislative intent. Their stance was that the 1937 Act was passed specifically to give Muslims a distinct legal identity based on Scripture. And crucially, they played the separation of powers card. Changing personal law is a job for the legislature, absolutely not something judges should be rewriting from the bench. So who won out? Let's dive into Part 5, the court's reasoning, which turned out to be an incredibly delicate balancing act. The Kerala High Court actually started off with a ton of sympathy for the petitioners. In a really interesting move, they looked at the global landscape and pointed out that many other Islamic nations have already reformed these exact laws. Countries have introduced mechanisms like obligatory bequests just to protect orphaned grandchildren. Yet, in India, this area of law has remained largely stagnant. The judges also highlighted a pretty glaring legislative gap. Acts like the Indian Christian Marriage Act or the Parsi Marriage and Divorce Act actually allow for secular applications. But the 1937 Sharia Act, it was historically designed as a mandatory unifying code, leaving absolutely zero wiggle room for individual secular choice. In fact, the court was incredibly explicit about this on the record. They openly stated that the current rules yield terribly unfair outcomes in modern society. When high court judges literally write into a judgment that a law causes drastic and unfair results for daughters and grandchildren, you know they see the profound inequity here. They heard the petitioners loud and clear.
But, and this is a massive but, the court's hands were ultimately tied. It all came back to the strict textual mandate of Section 2. That word shall is an explicit command. Plus, for you students taking notes, the judges relied on a massive legal precedent, Narsu Appa Mali. This precedent basically established that uncodified personal law isn't technically considered law under Article 13 of the Constitution. What does that mean? It means courts can't just easily strike it down for violating fundamental rights. The court realized they simply couldn't conjure up new words in a statute. Adding an opt-out clause is legislating, and legislating is the exclusive job of Parliament. So while wanting a secular law is a totally valid constitutional aspiration, the legal remedy just did not exist in that courtroom.
Which brings us to Part 6, the final judgment and the court's ultimate recommendation.
Ultimately, the court was forced to dismiss the petition. Legally speaking, the Shariat Act actively occupies that specific field, so there's no room for a judge to just override it. But they certainly didn't let the issue drop. They made a really powerful observation, confirming that the grievances of these women and orphan grandchildren were absolutely well-founded. They loudly proclaimed that it's high time the state considered reforming the law, or at least providing that exact opt-out clause the petitioners were asking for. Basically, they lobbed the ball squarely into the legislature's court.